The 14th session of the Senate in the second regular session of the 16th Congress is hereby called to order. The chamber will be led in prayer by Senator Joseph Victor G. Ejercito.
Magandang hapon, Ginoong Pangulo. Tayo po'y manalangin. Ama namin lumikha, nagtitipo po muli kami ngayon upang tupdin ang mga tungkuling inaatang sa amin ng sambayanang Pilipino. Batid namin, Panginoon, na bilang mga kinatawan ng mahigit 100 milyong Pilipino, kami ang nagsisilbing boses ng aming mga kababayan sa paglikha ng mga kinakailangang batas. Sa gitna ng mga pagsubok at kontrobersyang patuloy na sumusubok sa integridad at katatagan ng institusyon, naway maging instrumento ang aming kapulungan upang talakayin ang mga isyong pinakamalaga para sa kanila. Naway laging manaig ang pambansang interes sa aming mga pag-iisip at sa aming mga desisyon at pagkilos. Hinihiling din namin na higit na tumibay ang aming pagkakaisa upang higit na isulong ang kapakanan ng mamamayang Pilipino. Gagawin namin ito, Panginoon, bilang patuloy na pagpupuri sa inyong kadakilaan at kaluwalhatian. Naway patuloy kaming maging kalugod-lugod sa iyo at maging karapat-dapat sa pagtanggap ng inyong walang katapusang biyaya at pagpapala. Amen.
Amen. The Pag-ibig Fund Chorale will lead the chamber in the singing of the Philippine National Anthem, and after which they'll render a song entitled Magkaisa.
Bayang magiliw kaya sa silanganan, hanap ng puso sa itimpo'y buhay. Luhang inirang, duyan ka ng magiting, sa manlulupi, di ka pasisihil, sa dagat at bundok sa simula, sa langit mong bakaw, may dilagang tula at awit sa paglayang minamahal, ang isabang matawat mo'y tagumpay na nagdidinig, ang bituin at araw na kailan pa may di magdidilim, luma ng araw ng magkakit pagsinta, buhay langit sa piling mo. Ang hindi kaya ng magmay mga api, ang mamatay ng dahil sa'yo. iwasan ang gulo. Magsama tayo, magsipag-alay. Pakinggan niyo ang awit kong likha ng isipan. Hindi ba't tama ang aking mga pinagmasdan? Ang tangi kong layunin ay tayo'y magmahalan upang mabuhay ang pagkakaisa. Sabay-sabay sa pagpapahal patungo sa kinabukasan. Magsipag at tayo'y darating sa pagbabago'y laging may daan. Gumising na tayo'y basa, sabay-sabay sa pagtakpan patungo sa kinabukasan. Sikap tayo'y darating. Ang mabibig ko't may bukas pa, may bukas pa. Magkaisa, ikaw ako, lahat. Magkaisa, ikaw ako,
The Chamber would like to thank the Pag-ibig Fund Chorale. You are not only good at managing the funds, but also at rendering those beautiful songs. Thank you very much. The Secretary will please call the roll.
Roll call of members. The Honorable Senator Sangara, Aquino, Binay, Cayetano Alan Peter Compañero S., Cayetano Pia S., Defensor Santiago, Ejercito, Enrile, Escudero, Estrada, Gingona, Onasan, Lapid, Legarda, Marcos, Smeña, Pimentel, Po, Recto, Revilla, Soto, Trillanes, Villar, Senate President Trilon.
18 senators are present. The chair declares the presence of a quorum. The Majority Leader.
Magandang hapon po, Mr. President. 18 senators and one of them took the ice bucket challenge this morning. Congratulations. Mr. President, I move that we, with the consent of the Senate, that we dispense with the reading of the journal of the 13th session, August 27, and consider the same as approved.
Any objection? Hearing none, the reading of the journal of the previous session is hereby dispensed with, and the journal is approved.
Sir President, I move that we proceed with the reference of business.
The Secretary will read the reference of business.
Bills on first reading. Senate number 2375 entitled An Act Providing for the Accreditation of Non-Government Organizations and People's Organizations eligible to access government funds and for a system of accountability and transparency for the use of these funds by Senator Gingona III.
Electoral reforms and people's participation.
Senate number 2376, an act directing the Department of Education to include swimming lessons in the curriculum of all elementary and secondary schools by Senator Defensor Santiago.
Education, arts and culture, finance.
Senate number 2377, an act mandating the development of an age-specific program for students regarding career opportunities by Senator Defensor Santiago.
Education, arts and culture.
Senate number 2378, an act amending Article 15 of Republic Act number 3720, also known as the Food, Drug, and Cosmetic Act, requiring that foods containing spices, flavoring, or coloring derived from meat, poultry, or other milk products bear labeling stating that fact and under names by Senator Defensor Santiago.
Trade, commerce, and entrepreneurship, health, and demography.
Senate number 2379, an act to improve the efficiency of national research and development by Senator Defensor Santiago.
Science and Technology.
Senate number 2380, an act to promote the use of open textbooks by Senator Defensor Santiago.
Education, Arts and Culture, Finance.
Senate number 2381, an act to provide for systemic research and collection of information with respect to sports-related concussions by Senator Defensor Santiago.
Games, Amusement and Sports.
Senate number 2382, an act launching a national strategy to support regenerative medicine through funding for research and commercial development of regenerative medicine products and development of a regulatory environment that enables rapid approval of safe and effective products by Senator Defensor Santiago.
Health and Demography and Finance.
Senate number 2383, an act promulgating a comprehensive policy in addressing the needs of persons afflicted by rare disorders by Senator Sani Angara.
Health and Demography, Social Justice, Welfare, Rural Development, Ways and Means.
Senate number 2384, an act to develop and strengthen the agricultural education and training in the country through the institutionalization of manpower development for agricultural entrepreneurship in the post-secondary level by Senator Sani Angara.
Agriculture and Food, Education, Arts and Culture, Ways and Means, Finance.
Resolutions. PS Resolution number 869, directing the Committee on Public Works and other appropriate committees to conduct an inquiry in aid of legislation on the available and effective road capacity of Metro Manila for a comprehensive, integrated, and interdisciplinary approach in road management to avoid further losses arising from traffic congestion by Senator Lapid.
Public Works, Public Services.
PS Resolution number 870, directing the appropriate Senate committee to conduct an inquiry in aid of legislation on the government's alleged failure to protect against discrimination as well as to provide decent and proper accommodation to overseas Filipino workers, OFWs, who were recently repatriated from Libya by Senator Ejercito Estrada.
Labor, Employment, Human Resource Development, Foreign Relations.
PS Resolution number 871, commending Gabriel Luis Moreno for winning gold in the second Youth Olympic Games held in Nanjing, China, bringing honor to our country and exemplifying achievement through hard work and dedication worthy of emulation by Senator Sani Angara.
Committee on Rules.
Communications letter from the Bangko Sentral ng Pilipinas transmitting to the Senate copies of the following certified and authenticated BSP issuances in compliance with Section 15A of Republic Act Number 7653, the New Central Bank Act. Memorandum numbers M 2014-31 and 32 dated 18-11 August 2014 and Circular number 844 dated 11 August 2014.
To the Committee on Banks, Financial Institutions and Currencies.
Committee reports. Committee report number 72 submitted jointly by the Committees on Local Government, Electoral Reforms and People's Participation on House number 3917 introduced by Representative Fernandez et al. Entitled an Act increasing the number of members of the Sangguniang Panlunsod of the City of Biñan from 10 to 12 and separating it from the first legislative district of the province of Laguna to constitute the lone legislative district of the City of Biñan, amending for the purpose sections 10 and 61 respectively of RA number 9740, otherwise known as the Charter of the City of Biñan, recommending its approval with amendments sponsored Senators Marcos Jr. and Pimentel III.
Ordinary Business.
Committee report number 73 submitted by the Committee on Public Works on PS Resolution number 6 introduced by Senator Recto entitled a resolution directing the Senate Committee on Public Works to conduct an inquiry in aid of legislation on the viability of the approved overall master plan on flood management in the National Capital Region with the end in view of ensuring a comprehensive and cost-efficient solution to the flooding problem and would immediately bring relief to the public, recommending the adoption of the recommendations and their immediate implementation sponsors Senators Marcos Jr. and Recto.
Ordinary Business. The Majority Leader.
Mr. President, before the privileged speech of Senator Cayetano, may we welcome to the Senate Vice Mayor Andrew Goles of Silay Negros Occidental.
Vice Mayor Andrew Goles of Silay City is welcome to the Senate. Welcome, sir.
Mr. President, may we also welcome the President of the Metrobank Foundation, who is very at home here in the Senate, having been doing this work of honoring our public servants for a long time, Mr. Aniceto M. Sobrepeña. Together with him is Engineer Manny Gorospe, COPS CAPS Chairman, and Attorney Mike Leogardo, TOPS Chairman. May I ask them to rise to be recognized?
We welcome to the Senate Mr. Aniceto Sobrepeña, the President of the Metrobank Foundation, Manny Gorospe, the Chairman of the COPS, also of the Metrobank Foundation, and Attorney Mike Leogardo, 10 outstanding police in our chairman. Welcome to the Senate.
Seated behind them, Mr. President, are the outstanding teachers, outstanding members of the Armed Forces of the Philippines, and outstanding PNP officials and enlisted personnel, Mr. President. I will not name them individually because their names are in the resolution and will be read later on. At this point, Mr. President, I move that we recognize Senator Pia Cayetano to speak on matter of public interest.
Senator Cayetano is recognized.
Thank you, Mr. President. Today I take the floor to speak on the International Day of the Disappeared. May I first acknowledge those who are here with us today: Asian Federation Against Involuntary Disappearance, otherwise known as AFAD, May Eileen Bacalso, who's the Secretary General, Carolisa Peteros, and Kevin Mandrilla. Also from the families of victims of involuntary disappearance, otherwise known as FIND, Nilda Sevilla, the co-chairperson, Corazon Estojero, wife of a disappeared, and Ren De Vera, son of a disappeared. Mr. President, esteemed colleagues, the United Nations has declared August 30 as the International Day of the Disappeared. Today I rise on a matter of personal and collective privilege to commemorate this day and remember those who should not be forgotten, victims of enforced disappearances and their families. I first became involved in this issue sometime in 2009 when I met the mother of Jonas Burgos, who was abducted in broad daylight inside a mall in Quezon City. Until now, Edith Burgos does not know the whereabouts or the fate of her son. I felt a special affinity to Edith because, like her, I also lost a son. But our circumstances were very different. My son died due to a chromosomal disorder. He died in my arms, and although I have come to accept that I will never see him again in this lifetime, I am comforted by the knowledge that I was with him when he died. I wish this was a comfort that Edith Burgos and all the mothers, wives, children, and families of the disappeared could have. Enforced disappearance is widely considered as one of the gravest forms of human rights violations. It violates the most fundamental rights of a person: the right to liberty, life, and security, the right to dignity and to live free from fear, the right to family life, and the right not to be tortured. It infringes upon a person's right to truth, to effective investigation, remedies, and redress. When the disappeared is killed, he is stripped of his right to identification and proper burial or cremation. The persistence of enforced disappearance is a grave threat to the values and principles that we hold dear as a democratic society. It renders futile the rights we have fought for and enshrined in our Constitution. Without appropriate and urgent actions, more will be added to the long list of desaparecidos in the Philippines and worldwide. On December 21, 2012, the Philippines achieved a breakthrough in the enactment of the Anti-Disappearance Law, which established enforced disappearance as a separate offense in the country. Mr. President, nowhere else in Asia has this been achieved. This milestone, a legislative crusade that spanned almost 2 decades, is a significant step towards the goal of achieving a zero disappearance future for the Philippines. However, there remains 2 important gaps which should be addressed in order for the Philippines to prove its strong commitment to end disappearances. First, we must ensure full and strict implementation of the Anti-Disappearance Law. Second, and the focus of my speech, is the thorough study for consideration of the International Convention for the protection of all persons from enforced disappearance. The convention is a product of decades of struggle undergone by families of the disappeared around the world, who have fought for a normative and legally binding human rights instrument that crystallizes the right not to be disappeared, that guarantees non-repetition by providing for strong preventive mechanisms that establish state responsibility and accountability for non-compliance. Many of the convention's salient provisions complement the Anti-Disappearance Act of 2012, most of which are rooted in real-life experiences of the families of the disappeared. The Commission on Human Rights includes the signing of the convention in its strategic plan for 2011 to 2015, as this will help ensure the Philippines' compliance with international obligations, as well as cement our commitment to protect and promote human rights, especially the right not to be subjected to enforced disappearances. It will also manifest the state's solidarity with countries dealing with the issue of enforced disappearance, especially in Asia, the continent with the highest number of cases submitted to the United Nations. One important case of disappearance in the region is that of respected Ramon Magsaysay awardee, Sombath Somphone. Sombath is a prominent civil society leader from Laos who received the Ramon Magsaysay Award in 2005 for community leadership because of his exemplary work in sustainable agriculture and youth development. On December 15, 2012, Laotian police stopped Sombath's vehicle and abducted him. This was caught on CCTV camera, and he has never been seen since. Sombath's wife, Shui Meng, visited my office during the last session break to take up his case and gather support from neighboring countries. I would like to take this opportunity to express deep concern over the lack of serious investigation of Sombath's case as relayed to us by his wife, despite the Laos government signing and ratification of the Convention Against Enforced Disappearance. Human rights should never take a backseat in the ASEAN community, not now and not in 2015 and beyond. In the Philippines, we also have our own list of victims of enforced disappearance who, until now, have yet to be given justice. Mr. President, last month marked the apprehension of retired Major General Jovito Palparan, who has been charged with several human rights violations, including killings, torture, and enforced disappearance. The time has come for us to bring the issue of enforced disappearance back into the public sphere, to talk about this harsh reality and take action to prevent any more lives from vanishing without a trace. The list of desaparecidos in the Philippines and around the world has become too long and too painful to endure. One meaningful step towards ending this list is to closely study the International Convention Against Disappearance and consider its alignment with our own goals of giving justice to the desaparecidos and their families. Thank you.
Thank you, Senator Pia Cayetano. Majority Leader.
Mr. President, I move that we refer the speech to the Committee on Justice.
The speech of Senator Pia Cayetano is referred to the Committee on Justice.
Mr. President, with the consent of the Senate, I move that we consider proposed Senate Resolution number 836, taking into consideration proposed Senate Resolution number 858.
Any objection? Hearing none, consideration of the measure is in order.
Mr. President, may we request the Secretary to read the title and the text of the said measure.
Secretary will do so.
Yes, Resolution number 836. Resolution congratulating and commending the Metrobank Foundation's Outstanding Teachers of 2014. Whereas the annual Metrobank Foundation Search for Outstanding Teachers, SOT, was started in 1984 or 3 decades ago with the aim of bestowing due recognition and honor to teachers who devote their lives to the noble profession of molding the minds of our youth and teaching them with important values with remarkable dedication and exemplary competence. Whereas now, on its 30th year of this annual search, Metrobank Foundation, Inc. has remained relentless with its unwavering commitment to honor these outstanding teachers who fittingly serve as models of excellence that others in the same profession or otherwise could emulate. Whereas the Metrobank Foundation Inc. has so far honored 326 outstanding teachers of the Philippines who serve as shining examples of untiring dedication and commitment to the teaching profession, and who have given so much pride and joy not only to the respective schools and communities but to the nation as well. Whereas out of the 326 awardees, the Senate of the Philippines has recognized 110 of them from 2002 to 2013. Whereas the Senate of the Philippines continues to recognize the heroic dedication of the Filipino teachers to their vocation and maintains its highest respect for teaching as among the noblest of all professions. Whereas the outstanding teachers of our time deserve our accolade, considering that next to our parents, the teachers have the most impact on our lives, as they instill in the minds of their students good moral values as well as empower and train them to reach their fullest potential. Whereas we likewise should recognize the essential role of the teachers in education advancement, their important contributions in the development of humanity and modern society, and their rights as members of highly regarded professions. Whereas amidst the challenges and difficulties they face, our teachers remain reliable and committed to their avowed duty of educating the youth. Whereas the Senate of the Philippines gives due recognition to the outstanding teachers of 2014, chosen by the Metrobank Foundation Inc., consisting of 4 teachers in the elementary, 4 in secondary, and 2 in the higher education levels, namely Ana F. Abiliera, Naga Central School 1, Naga City; Sharon Rose P. Puyo, Cabadbaran South Central Elementary School; Inerio E. Abisa, PhD, Doña Juana Actob Lutz, Memorial Central School, Iligan City; Alan Moore S. Cabrillas, PhD, San Jose West Central School, San Jose City, Nueva Ecija; Juanito A. Merle, Doctor of Education, Talipan National High School, Pagbilao, Quezon; Jesus C. Insilada, Doctor of Education, Alcalde Gustilo Memorial National High School, Calinog, Iloilo; Matros P. Galarion, PhD, Angeles City National High School, Angeles City; Noel V. Ibis, PhD, Vinson's Pilot High School, Vinson's, Camarines Norte; Resurrection B. Sadaba, PhD, University of the Philippines, Visayas, Miagao, Iloilo; Teodora D. Balangkod, PhD, University of the Philippines, Baguio, Baguio City. Whereas this recognition is intended not only as a fitting tribute for educators who have excelled in the profession, but also to draw inspiration from their exceptional and selfless contribution to the pursuit of quality education. Whereas this recognition should inspire other teachers and even workers in other professions to perform outstanding service so that our youth will have a better future. Whereas we all aspire to enhance the country's quality of education by supporting genuine efforts to motivate our teachers, retrain and reward them for their life's work. Now therefore, be it resolved, as it is hereby resolved, to congratulate and commend the aforementioned 10 outstanding teachers of 2014, chosen by Metrobank Foundation Inc. for their exemplary dedication, competence, and service.
The Majority Leader.
Mr. President, I move that we recognize the sponsor, Senator Cynthia Villar, to deliver a sponsorship speech.
Senator Villar is recognized to sponsor the measure.
Mr. President, I would like to formally sponsor proposed Senate Resolution number 836, congratulating and commending the Metrobank Foundation outstanding teachers of 2014. I was honored to have been chosen as the chairperson of the Board of Judges of Metrobank Foundation 2014 Search for an Outstanding Teacher. On its 30th year, SOT remains the ultimate award search for the most excellent educators in the country. I would like to congratulate the 10 outstanding teachers this year. I-acknowledge po natin sila. Pwede silang tumayo. Anabelia Abiliera of Naga Central School 1, Naga City. Sharon Rose Puyo of Cabadbaran South Central Elementary School, Agusan del Norte. Inerio Ebida of Doña Juana Actub Memorial Central School, Iligan City. Alan Moore Cabrillas of San Jose West Central School, Pagbilao, Quezon. Jesus Insilada of Alcalde Gustilo Memorial National High School of Calinog, Iloilo. Matros Galarion of Angeles City National High School, Angeles City. Noel Ibis of Vincent's Pilot High School, Camarines Norte. Resurrection Sadaba of University of the Philippines, Visayas, Miagao, Iloilo. And Chodora Balangkod of the University of the Philippines, Baguio. According to William A. Ward, the mediocre teacher tells, the good teacher explains, the superior teacher demonstrates, the great teacher inspires. You are outstanding teachers, so you must have been doing all those and more. Keep up the great work. I have the utmost respect for teachers. Unknown to many, my late mother was a public elementary school teacher in Tondo, Manila. And I was once a teacher, a professor of finance at Far Eastern University. It is a privilege for both of us to have been part of the noble profession. Teachers' important contribution in every individual's life is in the society and in nation building can never be overemphasized. The impact and influence of teacher in a person's life is really unquantifiable. As historian Henry Adams noted, a teacher affects eternity. He can never tell where his influence stops. Teachers do not just educate in academic terms. They build characters, they instill good manners and right conduct, they develop virtues, they shape minds, they prepare their students for the future. They empower and train them to reach their fullest potential. Thus, as I cited on the proposed Senate resolution, the outstanding teachers of our time deserve our accolade, considering that next to our parents, teachers have the most impact in our lives. I also would like to commend Metrobank Foundation for its tireless efforts in recognizing the competence and commitment of Filipino teachers. They have so far honored 326 outstanding teachers of the Philippines. To the recipients of these awards, may your tribe increase. Magsilbi sana kayong inspirasyon, hindi lamang sa inyong mga estudyante, kung hindi sa iba pang mga gurong Pilipino. Mabuhay kayong lahat.
Thank you very much, Senator Villar. The Majority Leader is recognized.
Mr. President, I move that we approve proposed Senate Resolution number 836, subject to style.
Any objection? Hearing none, proposed Senate Resolution number 836 is hereby approved.
Mr. President, may I request that all senators present be made co-authors of this measure.
Let the record so reflect the co-authorship of all the senators present.
Mr. President, I move that we suspend the session to allow the senators to congratulate the awardees and to ask them to approach the Senate President podium for a photo session opportunity.
Session is suspended for 1 minute.
Sir. Ready to resume, Mr. President.
Session is resumed.
Mr. President, with the consent of the Senate, I move that we consider proposed Senate Resolution number 792.
Any objection? Hearing none. Proposed Senate Resolution 792 is in order.
Mr. President, may we request the Secretary to read the title and the text of the said measure.
The Secretary will read the title and content of proposed Senate Resolution 792.
Resolution honoring and commending the outstanding Philippine soldiers, TAPS of 2014. Whereas the search for the outstanding Philippine soldiers, implemented since 1999, is an annual project of the Metro Bank Foundation, Inc., in partnership with the Rotary Club of Makati Metro, in consonance with the conviction of both these organizations to honor excellence in the pursuit of a vocation. Over the years, the search for TAPS has become the highest and most sought-after civilian award given to military personnel. Whereas the competition is an expression of gratitude to the heroism, gallantry, dedication, and sacrifices of the gallant men and women of the Armed Forces of the Philippines. In 2003, the search for TAPS became a career achievement award that recognizes the contribution of the soldier's best 7 years of his or her service in the military. Whereas the search awards a maximum 10 winners, which shall be chosen from among the commissioned officers from each of the major branch of service with the rank of captain up to colonel, and enlisted personnel who are at least in the active service of 7 years, and from among all commissioned officers with the rank of captain up to colonel of the technical and technical service of the AFP. Whereas the competition raises the model of excellence within the military, which the other soldiers should emulate, represents the ideals being upheld by the larger sector of the national community represented by both the Metro Bank Foundation, Inc. and Rotary Club of Makati Metro, and likewise highlight the contribution of the AFP-NP's security, nation building, and development. Whereas the Philippine Senate proudly joins the Metro Bank Foundation, Inc. and Rotary Club of Makati Metro in honoring and commending the gallant men and women who have risked life and limb in the defense of our country's sovereignty through the 2014 search for the outstanding Philippine soldiers. Whereas the roll of honor for this year's winners for the search for TOPS consists of 3 men from the Philippine Army, 2 men and 1 woman from the Philippine Air Force, 3 men from the Philippine Navy, and 1 man from the Medical Administrative Corps of the AFP. Wherefore, be it resolved by the Philippine Senate to honor and commend the outstanding Philippine soldiers chosen by the Metro Bank Foundation, Inc. and Rotary Club of Makati Metro and the 2014 search for TOPS, namely, for the Philippine Army, Commissioned Officer Category, Colonel Teodoro A. Llamas, PA, Acting Regiment Commander, Light Reaction Regiment, Special Operations Command, Philippine Army, Fort Ramon Magsaysay, Palayan City. Enlisted Personnel Category, Master Sergeant Aladin S. Dakayanan, PA, Group Sergeant Major, Military Intelligence Group 22, Intelligence Service, Armed Forces of the Philippines, Western Command, Puerto Princesa City. Staff Sergeant Rehum P. Magno, PA, Platoon Sergeant, 3rd Scout Ranger Company, 1st Scout Ranger Battalion, 1st Scout Ranger Regiment, Special Operations Command, Philippine Army, San George, Western Samar. For the Philippine Navy, Commissioned Officer Category, Captain Alberto B. Carlos, PN, Assistant Chief of the Naval Staff for Logistics, N4, Headquarters, Philippine Navy, Naval Station, Jose V. Andrada, Roas Boulevard, Manila. Enlisted Personnel Category, Sergeant Eugene J. Padilla, PN, Team Leader, Assistant Radioman, 62nd Marine Company, Marine Special Operations Group, Headquarters, Marine Special Operations Group, Marine Base, Gregorio Lim, Ternate, Cavite. Commissary Steward, 2nd Class, Felix B. Guaves, the 2nd, PN. Assistant Team Leader / Platoon Sergeant, Naval Special Operations Unit 8, Naval Operations Group, Philippine Fleet, Naval Base Heracleo, Alano, Sangli Point, Cavite City. For the Philippine Air Force, Commissioned Officer Category, Lieutenant Colonel Adriano S.J. Duadico, Philippine Air Force, Deputy Group Commander. 480th Maintenance and Supply Group, 250th Presidential Airlift Wing, Headquarters, Philippine Air Force, Colonel Jesus Villamor Air Base, Pasay City. Enlisted Personnel Category, Technical Sergeant Benny G. Dofitas, PAF. Non-commissioned Officer in Charge, Image Reap, Photo Lab Flight. Assistant First Sergeant, 306th Air Reconnaissance Squadron, 300 Air Intelligence and Security Group, Philippine Air Force, Headquarters, Philippine Air Force, Williamsburg Air Base, Pasay City. Staff Sergeant Cheryl P. Toribio, Non-Destructive Inspection Specialist, 4111 Aircraft Systems Maintenance Squadron, 410th Maintenance Wing, Clark Air Base, Pampanga. For the Technical and Administrative Service, Medical Administrative Corps, Major Florencio Ricci I. Capulong III. Head Registrar Department, Special Disbursing Officer, Acting Logistic Officer, Armed Forces of the Philippines Medical Center, V. Luna General Hospital, Luna Avenue, Quezon City, for their loyalty and dedication to the Constitution of the Republic of the Philippines, for their faithful performance of their sworn duties and responsibilities beyond reproach, and for being model citizens in the respective communities.
Sir President, I move that we recognize Senator Angara to deliver a sponsorship speech.
Senator Angara is recognized to sponsor the measure.
Just a brief manifestation, Mr. President. Thank you, Majority Leader. Dear colleagues, I had the privilege of chairing this panel of the Board of Judges for the 10 outstanding soldiers of the Philippines. And I was truly a witness, or we were on the Board of Judges, were truly witnesses to the outstanding bravery and sacrifice exhibited by these 10 outstanding men and women. And once more, let me reiterate our gratitude for their sacrifice. Nakita po namin yung superhuman side nila. Many of them faced death, had episodes where they faced, they saw death in the face and stared it down. And we also saw their human side because many of them, when asked about what was the most difficult thing about being in the service, most of them said it was being away from their families. So that is the difficulty of being in the service, Mr. President. And for that double difficulty of their duties and their sacrifice, we pay tribute to them on this day, and we thank them for their protecting us and making our way of life possible. So salamat at mabuhay po sila.
Thank you, Senator Angara. Majority Leader.
Sir President, I move that we approve proposed Senate Resolution number 792, subject to style.
Any objection? Hearing none. Proposed Senate Resolution number 792 is hereby approved.
Sir President, may I also request that the senators present share with the honor of this resolution and be made co-authors of the said measure.
The members present are made co-authors of this resolution.
I move that we suspend the session to allow the senators to congratulate the awardees and for photo opportunity, Mr. President.
Session suspended for 1 minute. Oh, okay na? Session is resumed. Majority Leader is recognized.
Mr. President, with the consent of the Senate, I move that we consider proposed Senate Resolution number 827.
Any objection? Hearing none, consideration of the measure is in order.
Mr. President, may we request the Secretary to read the title and the text of the said measure.
Secretary will read the title and the text of the proposed Senate resolution.
Resolution commending and congratulating the Philippines' 10 outstanding police officers in service, COPS, of 2014 as selected and sponsored by Metrobank Foundation, PS Bank, and the Rotary Club of New Manila East. Whereas the search for the country's outstanding police officers in service, COPS, is an annual recognition program jointly undertaken by the Metrobank Foundation, Inc., Rotary Club of New Manila East, and PS Bank that aims to honor models of professionalism, competence, dedication, and integrity among the 148,000 members of the Philippine National Police. Whereas the search is an expression of the civilian sector's appreciation and gratitude to the effort of the Philippine National Police in maintaining the peace and order situation in the country. Whereas COPS serves as the social contract of the Metrobank Foundation, Rotary Club of New Manila East, and PS Bank to the police force that will advance the welfare of the PNP and contribute in the realization of the integrated transformation program of having the institution as a highly capable, effective, and credible police service working in partnership with a responsive community. Whereas the search seeks to honor the gallant men and women in the police force for the consistent, outstanding contributions in preventing and solving crime through community work and mobilization. Whereas the search emphasizes the need to situate the punitive aspect of law enforcement with the task of community relations and promotes police work as a shared responsibility between the police officers and the community. Whereas the competition awards a maximum of 10 winners, which shall be chosen from among all the police commission officers with a rank of police inspector to police senior superintendent and police non-commissioned officers with a rank of police officer 1 to senior police officer 4. Whereas the Philippine Senate proudly joins the Metrobank Foundation, Inc., Rotary Club of New Manila East, and PS Bank in congratulating and commending the police officers who have actively solicited, mobilized, involved, and organized the community to become fellow vanguards of the community through the 2014 Metrobank Foundation search for the country's outstanding police officers in service. Whereas the Roll of Honor for this year's winners of COPS consists of 4 police commissioned officers and 6 non-commissioned officers. Now therefore be it resolved as it is hereby resolved by the Philippine Senate to congratulate and commend the Philippines' 10 outstanding police officers in service of 2014 as selected by the Metrobank Foundation, Inc., PS Bank, and the Rotary Club of New Manila East, namely, from the Police Commission Officers category, Police Senior Superintendent Cedric Gayona, train. Police Senior Superintendent Rodelio Balsa Hoxon. Police Chief Inspector Byron Filog Alatog. Police Chief Inspector Reynald Estrada Arino. From the Police Non-Commissioned Officers category, Police Officer 3 Michael Dalisay Pontoy, Senior Police Officer 1 Reynaldo Granada Sulante, Police Officer 2 Arshir Usman Ismael, Police Officer 3 Alexander Baradillo Fason Jr., Senior Police Officer 1 Ray Hinautan Sarcon, Police Officer 3 Comet Dimla Dumangeng.
Majority Leader.
Mr. President, I move that we recognize Senator Grace Poe to deliver sponsorship speech.
Senator Grace Poe, the Chair of the Committee on Public Order.
Thank you, Mr.
is
President.
recognized.
Thank you, Mr. President. It was truly an honor to be selected to be one of the judges for the Metrobank's 10 outstanding police officers in service. It was an honor for me to be able to hear the stories of our police officers, especially the ones that were chosen because of their outstanding service to our country, their actions that are worth emulating, and what they have accomplished in spite of in spite of all of the problems that they have encountered in their jobs. Sa ating mga kababayan na nangangarap pa na maging pulis, sila po ay magandang ehemplo dahil po sa kanilang mga pinakita sa kanilang trabaho at sa tulong sa kanilang komunidad. Marami po sa kanila, Mr. President, ay hindi nabibigyan ng sapat na tulong pinansyal ng ating gobyerno, pero gayon pa man, kung ano man ang meron na magagawa sila para matulungan ang ating mga kababayan, ay kanilang ginagawa. Kaya po, isa pong karanasan para sa akin ang matuto kung ano man ang problema ng ating mga kapulisan ngayon at kung ano ang ating magagawa bilang mga mambabatas para naman maibsan din ang kanilang kahirapan at matulungan sila. So again, Mr. President, I would like to congratulate the winners for this year's 2014 10 Outstanding Police Officers in Service.
Thank you, Senator Po. The Majority Leader, please.
Mr. President, I move that we approve proposed resolution number 827, subject to style.
Any objection? Hearing none. Proposed Senate Resolution number 827 is hereby adopted.
Mr. President, may I request that all senators be made co-authors of this measure?
All members present are made co-author.
Mr. President, I move to suspend the session to allow senators to congratulate the awardees and also for a photo opportunity.
Session is suspended for 1 minute.
Nandun ba? Oo nga, no? Mga 420.
Tawag mo na si Senator Bang.
Tama, no?
Ready to resume, Mr. President.
Session is resumed.
Mr. President, I move that we resume consideration of Senate Bill number 2055 under Committee Report number 12. This is the Forestry Profession Bill, Mr. President.
Any objection? Hearing none. Resumption of the consideration of Senate Bill 2055 is in order.
Mr. President, the status of the measure is that we are in the period of individual amendments. I thus move that we recognize Senator Sonny Trillanes, the said sponsor.
The principal sponsor, Senator Trillanes, is recognized.
Thank you, Mr. President.
Mr. President, there are no other senators who have registered to make amendments. Therefore, I move that we close the period for individual amendments.
Any objection? Hearing none. Period for individual amendments is hereby terminated.
For the record, Mr. President, there are no committee amendments. Mr. President, I move that
Period
we...
for committee amendments is terminated.
Mr. President, I move that we approve Senate Bill number 2055 under Committee Report number 12 on second reading.
Any objection? Hearing none. Senate Bill number 2055 under Committee Report number 12 is hereby approved on second reading.
Mr. President, I move that we suspend consideration of Senate Bill number 2055 under Committee Report number 12.
Consideration of the measure is hereby suspended.
Mr. President, I move for a minute suspension.
Session suspended for a minute.
As far as we just sent lang naman 33 questions para.
Ready to resume, Mr. President.
Session is resumed.
Mr. President, I move that we resume consideration of Senate Bill number 2282 under Committee Report number 56. This is the Fair Competition Bill, Mr. President.
Consideration of Senate Bill 2282 under Committee Report 56 is in order.
Mr. President, the status of the measure is that we are in the period of interpellation. I thus move that we recognize the sponsor, Senator Aquino.
Senator Aquino is recognized, the principal sponsor.
To continue in his interpellation, I move that we recognize Senator Angara.
Senator Sonny Angara is recognized to continue availing of the period of interpellation. Senator Angara.
Thank you, Mr. President, Mr. Majority Leader, dear colleagues. Would the good sponsor yield to a few, well, more than a few questions
Gladly,
on this
Mr.
occasion?
Mr. President.
Thank you, the good sponsor. We had a good discussion last week, Mr. President, and picking up on that, I was reading the journal, and the principle of substitutability of goods was mentioned with respect to determining the extent of or the definition of a market, which is a very important process that the FCC or the Federal the Commission or the Fair Competition Commission must determine. So could Mr. President, the sponsor, say something a little bit about that principle?
Yes, Mr. President, the theory of or the principle of substitutability is actually at the core of the Commission, no? And the idea of promoting competition, because at the end of the day, it will really depend on the appreciation of the Commission on the substitutability of goods in the relevant market to be able to decide on matters. No? So, for example, one could argue that the slippers industry and the shoe industry could be substitutable. No, one could argue that in the beverage industry, water can be substituted for soft drinks or for other matters. No? Now, Mr. President, I will have to admit that in the current version of the law, we really kept it broad because the nature of competition is that markets change, no? And if you were to ask 25 years ago, you could say that our markets were very constrained to the Philippines. But these days, we're already talking about an ASEAN market or even a global market. And even if we look at the different industries in the Philippines, some have reached global status and others are, you could even say, might even be regional, no? So, I understand, Mr. President, the concern that with quite a broad definition, it does give a lot of powers to the Commission to be able to decide on substitutability and relevant market. But we chose to err on the side of applicability, Mr. President, no? Because if we constrict the definitions too narrowly, it might come to a point where it is already not applicable in current industries or markets. So in short, Mr. President, it is quite important, it is quite key. We will welcome amendments if there are to refine or to define this further. But the current version of the bill is such that we kept it to the Commission to be able to decide on these matters specifically.
Thank you, Mr. President. Well, since we're on the subject of market, would I suppose some goods or services would lend themselves more readily to substitutability, and some would not because of the nature of the business. I think the power industry perhaps comes to mind.
Yes.
I'm sure the sponsor has many others. Would he care to elaborate? Is there a rule of thumb as to substitutability of certain businesses, or is there such a thing as low substitutability or high substitutability, for example?
Yes, actually, Mr. President, when you look at specific products, if the differentiation is very low, then it is likely that they can be substitutable. But there are cases where even a slight difference in the product might necessitate that they're not. So again, Mr. President, it's very difficult to give hard and fast rules here, But in effect, I'll give you another example, Mr. President, There can be exactly the same product, but they're not substitutable because of inability to enter the same market. For example, in the power industry, for example, you could be a power generator in place A, and you could be another power generator in place B, but you cannot consider them as substitutable because you cannot transmit that power to the same areas. So even if they're the same product, because of geography or other reasons, they may not be substitutable. But I guess, Mr. President, the rule of thumb for probably the majority of products and services would be that if there's very small differentiation, then they're likely to be substitutable as well.
Let me go to Mr. President, to the concept of dominant position. And one provision of the Act says that a price cut by or pricing below cost would not be considered a violation if done by a smaller player. Is this correct?
Yes, Mr. President. No. First of all, you need to define the market. Once you're able to define the relevant market, then you can actually make a decision on whether their action is controlling the market or making it difficult for competitors to join. So in the case of a minor player, Mr. President, if in that market they are considered a minor player, then automatically they cannot be accused of predatory pricing, because they don't have the capacity to cut out or to make a difference in the market or cut out competitors because of their size.
Who is a minor? When you say a minor player or in the market, how is that defined in the bill?
Minor player is not, Mr. President, but dominant player is, When we say dominant player, we mean they have the capacity to control the market or to stop competitors from entering the market. So in that sense, Mr. President, everyone else who is not dominant, at least in the current discussion, is a minor player or non-dominant player.
It does not depend on the size of the market that the minor player would control.
No, Mr. President. It doesn't depend on the market itself. What depends is whether they have the ability to control the market or not, or to edge out competition. If you do have that status, then you're considered a dominant player, Mr. President.
Yeah, just for that clarification. Thank you.
Thank you.
Thank you, Mr. President. So the standard is different when it comes to a dominant player in the market. But my question is, there is a power given to the FCC to adjust prices or to fix prices. Is this correct, Mr. President?
Mr. President, I don't think there is, but maybe you could elucidate further, Mr. President, on a particular provision that you are mentioning.
Yeah, it's here somewhere. It's section 8 in functions and powers of the Commission, Mr. President. That's
What letter, Mr. President?
section 8D. Says powers and functions of the Commission. Upon finding that an entity has engaged in anti-competitive act or behavior, stop or redress the same by applying remedies such as but not limited to imposition of price controls. So, that was the phrase I...
Yes, Mr. President, that's already actually a remedy. So that power will emanate from a ruling that there is anti-competitive behavior. In the same way, Mr. President, that once there's a ruling, there are different remedies that can be done aside from the fines. They can be asked to stop their operations, which is the injunction and so on and so forth. So, Mr. President, that's as a ruling to a decision already made.
Could a minor player, Mr. President, be guilty of anti-competitive behavior if they priced below cost, for example?
If they don't distort the market, Mr. President, then no. Because again, Mr. President, we have to go back to the presupposition that they have the capacity to distort the market, to stop competitors, to affect the market. So in that case, Mr. President, if they're a non-dominant player and their action is one where they lowered prices but then they did not affect the market, or upon the appreciation of the Commission, their move did not really affect the market greatly, then they wouldn't be in violation of the prohibited acts, Mr. President.
What if a minor player was smuggling or declaring the wrong taxes, for instance?
Well, actually, Mr. President, that they're in violation of a separate law.
Yes, but would the tentacles of the FCC extend to? Because it says here there's some kind of coordination of jurisdiction where the FCC could actually order other agencies of the government to perform certain acts.
They can deputize, Mr. President.
They could deputize.
No? But in particular, their mandate is really on competition. So they don't have a mandate with regard to tax evasion or smuggling. In that case, Mr. President, it would be BIR or BOC that would go after them. No? Now, if they're a dominant player and it's proven that there is predatory pricing and they're doing that because they're smuggling or misdeclaring their taxes, then they would be liable for all of the different laws that they are breaking, Mr. President. And surely our government agencies will literally throw all of the necessary laws or the applicable laws against them if they are doing such.
Okay. There's a concurrent jurisdiction between the FCC and the DOJ. What is this office? The office OFC.
Office of Competition, Mr. President.
Office of Competition. And I think criminal jurisdiction you mentioned belongs to the DOJ, whereas administrative and civil belongs to the penalties belong to the FCC. Would it be possible to have a case where there would be conflicting findings by the two agencies?
Mr. President, no. On its face, we don't really see how that could happen because they're adjudicating on different matters. One is really on administrative and civil, and the other one is on a criminal case, Mr. President. So the cases will happen in parallel, and because again, it's a different prohibited act technically. No, sorry, let me correct that, Mr. President. It's the same prohibited act, but because the penalties are different, the Department of Justice will rule on a criminal basis. So meaning, it's possible that the evidence did not reach the level needed for a conviction on a criminal case, but then the level of evidence reached what was needed for an administrative case. So it might be possible, Mr. President, that one does not rule on them negatively and the other one does.
Understand. So it's possible to have for the Commission to impose a fine, whereas the DOJ would dismiss the case. That's possible.
That's possible, Mr. President.
In the same vein, Mr. President, is it possible for a specific industry regulator and the FCC to have the differing or conflicting interpretations of the law? Is that possible, Mr. President?
Mr. President, it's not also, Mr. President. To be clear, there are actually only two regulators who share a competition mandate, and that is the ERC and the NTC. And the rest of the regulators, Mr. President, do not have a competition mandate. They do have a regulation mandate. And it's quite clear, Mr. President, that in matters of regulation, the FCC does not rule on that. They only rule on matters of competition. Now, for the cases of NTC and ERC, the idea, Mr. President, is that they will undergo a MOA before they rule on any case to decide who will have the jurisdiction on the matter. So based on the MOA, they will have to respect the findings depending on the memorandum of agreement that they undertake with either ERC or NTC.
I think, if I'm not mistaken, Mr. President, the EPIRA law contains provisions also on anti-competitive behavior, no?
Yes, Mr. President.
And these are sought to be repealed by this bill.
Yes, Mr. President. No, there is a repeal, no. Let me look at the exact provision, Mr. President. No, what section is that? Yeah, actually, Mr. President, it's not a complete repeal of Section 45. No, it just basically says that the Competition Commission does also have a competition mandate aside from the ERC. However, Mr. President, let me also mention that the current version in Congress actually does repeal EPIRA and gives all of the competition mandate to the FCC. Our version shares it, Mr. President, with the ERC, and before any ruling is done, a MOA is undertaken among them, no, between the FCC and the ERC. That's different, though, from the version in Congress, where primary and exclusive jurisdiction on competition is given to the FCC, thereby totally repealing or modifying the Section 45 of EPIRA. So, Mr. President, our current version does repeal it, but not completely, because it still does allow the ERC to keep its competition mandate. The FCC also has a competition mandate. Then when they rule on anything, they undergo a MOA.
Under the EPIRA, I found the provision, Section 45, talks about cross-ownership, market power abuse, and anti-competitive behavior. And it gives specific percentages which are allowable or disallowed. Would the effect of the entry into force of the competition law replace these percentages?
No, Mr. President.
So we would still be
subject to those.
These percentages would still be enforced.
In my version, Mr. President. In our current Senate version.
In the current Senate
yes.
version. Okay. Could we talk about leniency programs, Mr. President? It seems to be a version of a witness protection type of thing, no?
Yes, Mr. President. And there are aspects to the bill that talk about the witness protection aspect. Now, we understand that the current bill has not yet been passed into law, but if there is a need to harmonize some of the provisions ahead of time, now we're very happy to accept that as amendments down the line.
But the government has an existing witness protection program, so it does not seek to modify this insofar as insofar as the entities
Mr. President, let me compare the current program of the DOJ and what we have, no, and maybe we can try to harmonize that, Mr. President. We don't obviously want to have too many different regimes ruling on one particular aspect. But to be frank, when we crafted this, we did it without looking at the current DOJ program. But we will check on that, Mr. President.
Well, it seems wider in a sense, Mr. President, because it uses the word entity. So does that exclude individuals? Because it uses the provision uses the word entity.
It does include persons.
It's
Mr.
both
President.
juridical and natural
Yes.
persons.
Yes, Mr. President.
I see. There are a lot of powers under the FCC, Mr. President. There are injunction powers, cease and desist order powers under Section 8. Is there a need for notice and hearing?
Actually, Mr. President, with regard to the cease and desist order, what happens is that there is it is issued during a preliminary inquiry, Mr. President. No? So the general rule, Mr. President, is that a notice and hearing will be provided. But this isn't done arbitrarily, Mr. President, and that there is an actual case that is being taken up. In fact, Mr. President, there was one suggestion from the private sector that for all of the preliminary inquiries done by the FCC, that they should be posted on the website or made known, no, so that there won't be any secret cases being done. Then a CDO will be given without any prior notice. So actually, Mr. President, in the case of a cease and desist order, it is during a preliminary inquiry, and that generally there should be a notice and hearing issued.
So it is a requirement to have notice and hearing.
It is, Mr. President, and in fact, it is in keeping with the due process provisions that's encased in our Constitution.
Perhaps we should make that explicit later on, Mr. President.
Oh, we would welcome that, Mr. President.
And also, there's a power to conduct searches under Section 8G.
Yes, Mr. President.
It says the Commission may undertake inspections of business premises and other premises, including land and vehicles, homes of entity directors, officers, and employees during business hours, where it reasonably suspects that relevant books, tax records, or other documents, so on and so forth. Is this meant to? Is this provision? Are these acts or these searches done without a search warrant issued by a court, Mr. President?
Mr. President, of course, if a search warrant is issued, then obviously that can be done, no? But the idea here is that it is akin to BIR and BOC, for example, Mr. President, asking for documents, no, from the entity in the case where they want to investigate further upon the books of the entity. So the idea here, Mr. President, that once the agency gives notice, much like other agencies of government, that the questionable entity does provide the documents. No? Now, there is a concept, Mr. President, in other jurisdictions called a dawn raid, no? Where to stop companies from shredding their books or deleting their hard drives, that a raid can be done. Now, in those cases, Mr. President, a search warrant would probably be necessitated, no? You would need that. But in the case where you're asking for documents, they can just give notice. And this is quite similar, Mr. President, to other government agencies who want to look into your books further, no? And if I'm not mistaken, the BIR is able to do this, no, when they want to make a judgment on your finances. So in the same vein, Mr. President, the FCC can provide notice to a company and ask them to provide their documents.
Mr. President, I ask because it's one thing to provide documents, but it's quite another to have your home sort of have officials of the government barge into your home. There's a long line of cases which uphold the sanctity of a person's home. These are the cases on the fruit of the poison tree doctrine, as the Senate President very well knows. And the thought behind that is no matter how humble a person's abode is, that's still his castle.
That's right.
It's still sacred. So you're is it to say that the same requirement of documents apply to the search of a home?
Mr. President, no, and let me clarify this one. And if there is a need to refine this provision further, to be, how do I say it, to echo some of these concerns that you've had, we will welcome this in the period of amendments. But the idea here is that the Commission can request for documents, and if there is inaction of the entity, or if they refuse to do so, then probably a search warrant can be issued. And once the search warrant is issued, then the documents can be seized in the homes, in the offices, etc., etc. I guess, Mr. President, the idea that we wanted to put here is that the FCC does have that power to request and compel entities to provide documents. No? So in short, Mr. President, if you wish to clarify these amendments, these provisions further through amendments, we would welcome that.
Yes, I think there's a need perhaps to make it explicit, Mr. President, later on. If we can go back to the abuse of dominant position, the sponsor mentioned predatory behavior, selling at lower prices. Would there be exceptions to this type of behavior? Because I think it's business practice to sell at lower prices when certain products are being phased out, or certain stores are being closed, or certain stocks are being discontinued, for example.
Yes, Mr. President, no, that's a good question actually, because the principle of predatory behavior is that it's done to force competitors out of the market. So on that, Mr. President, if you're phasing out or you're closing already, kumbaga nagano ka na, everything must go sale, parang ganyan, di ba? Your intent definitely is not to force anyone out of the market because you are closing or you are phasing out your company. So in that case, Mr. President, it wouldn't apply, no? But then again, it would be difficult to imagine a dominant player, again, which is another presupposition of predatory pricing, a dominant player going to phase out automatically, no? So of course, it's different, Mr. President, if they're just using that as a ruse, no, to lower their prices, no, meaning phase out sila ng phase out kada buwan, and then mag-closure sila pero 10 taon na pa-close na sila. Ibang usapan 'yon, Mr. President. But right, if they indeed are closing shop or phasing out, then I can't imagine that they would be a dominant player, Mr. President. But even if they are, the requirement that it's done to force out competition when they're actually leaving the market already wouldn't be in play, Mr. President. So phase out or closure, actually, you cannot be accused of predatory pricing.
That's very clearly explained, Mr. President. If we could move to mergers and acquisitions.
Before that, can we just the chair has some clarificatory questions.
Go ahead,
on with the permission of Senator Angara, on this matter of the prohibitions on an entity in a dominant position. We know this to be happening in the market. A soft drink company would provide an outlet or a sari-sari store with a refrigerator, provided you will only sell the product of that soft drink company. Now, if you are the dominant, if the soft drink company is in a dominant position, that is prohibited.
Yes, Mr. President.
What if the company is not in a dominant position and commits exactly the same act? Is that prohibited?
Mr. President, if you can give me a minute, because this is a very technical answer and this will affect a lot of the people listening, so if you can give me a second.
One minute suspension.
Possibility of selling other things. Okay. Yeah, it's not. It's not bad.
It's not prohibited unless there's no other recourse.
Okay. Yeah. Yep. Itong mga, itong 13 and up. Very to very. C13 muna. 13.
Session is resumed.
Mr. President, if I may answer your query earlier. In principle, if you're a dominant market, if you're a dominant player, and you are doing an action which greatly restricts competition in the market, then as a general rule, definitely bawal po yun. That is not allowed. But in the appreciation of the example that you gave, which is on the soft drink market, you would have to look at the market as a whole rather than just one sari-sari store, no? And you have to ask yourself, in this market, are there ways that I can get competitors freely and openly without restriction? And in that case, Mr. President, if you define or if you look at that, you wouldn't be able to say that this particular industry is restricted, because any of us can go to a sari-sari store, supermarket, and find different types of beverages available. So in that case, Mr. President, one particular action, if it does not affect the market, so it's not prohibited, no? And I guess, Mr. President, this goes back to the question of the gentleman from Aurora, where he asked earlier about relevant market, no? And the possible difficulty of the Commission in determining cases, because they will have to look at what's actually happening in the market at that particular time, in that particular geography, Mr. President, and first determine if indeed that market is impeded or is hampered. So in that case, Mr. President, that exclusive deal does not hamper the totality of the soft drink or the soft drink market or beverage market. So in that case, then that would not fall under the prohibited acts here.
Now, is this also a criminal act? Is it punishable by imprisonment or a fine? Assuming that you're a dominant player, etc. Is this among the acts penalized under the proposed measure?
If it is predatory behavior, Mr. President, if it is part of the prohibited acts, which we suppose that the market is indeed infringed, no, or impeded, then yes, it could be a criminal act. But again, Mr. President, you would have to look at the totality of the market and the intent as well.
Yeah. Because that is a departure from what we understand to be a punishable criminal act. Under the way we understand it, the penal statute, the act is itself criminal. If the act is itself criminal and it is defined as a criminal offense, then you are punished for that act. In this particular case, the act may or may not be punishable depending on the effect on the market.
Yes, Mr. President. And in fact, it also depends on your status.
Correct. Because, depends on your status.
If I'm not mistaken, Mr. President, even our current laws, there's not much where your status is actually in play, no? But in this case, your status in the market or your relative position in the market will also be a factor.
Are there existing laws which will be of a similar nature as the proposed measure that you are, as the proposed criminal acts that you are defining here? Because, as I said, this is something that is new in our jurisdiction.
Definitely.
As we know it, an act, if it is considered as criminal, then it is punished. But in this particular case, there are certain circumstances which, beyond the control of the actor, which may or may not make the act a criminal act, and that is the effect on the market. I mean, I do not have answers to my questions. I'm just asking you whether or not this indeed is feasible under our present penal statute. Now, I guess my question is, In other jurisdictions, how is this treated? Is this treated as a criminal act?
Mr. President, no, in most jurisdictions, their competition commission just rules on administrative and civil liabilities. No, in our case here, there is a provision which allows the DOJ to still rule on criminal acts.
Precisely, that's my question, Mr. Sponsor. Are there other jurisdictions other than in other jurisdictions? Would a criminal act of similar nature, would an act of a similar nature be considered as a criminal act where certain circumstances are present?
In the case of price fixing of cartels, Mr. President, where their price fixing does affect the market greatly, then that's quite similar, no, in other jurisdictions. But we could actually submit to you, Mr. President, a more detailed answer to that question later on. No? Obviously, we cannot come up with the answer off the top of our head in terms of other jurisdictions right now, but we could look for that, Mr. President, and send that over to the committee.
I guess we should spread that into the record because this is a statute where if it becomes law, then the debates in this hall will be a very critical reference point as to the application of the law.
If I may add, Mr. President, to the discussion, the congressional version actually did away with the criminal acts, no? And they kept it at admin and civil. Oh, sorry, Mr. President. They took it away for most, but they retained it for price fixing and cartels and cartel-like behavior. But everything else, Mr. President, they didn't include it in the criminal acts.
That's why. So that precisely is the issue that we are raising at this point. In the particular case of abuse of dominant position, it is a criminal offense. Is that correct?
Currently, Mr. President, it is. In the congressional version, in itself, they took it out, no, of the during their committee hearings and caucuses. They took that out. The only matters that they kept as criminal acts were price fixing due to cartel-like behavior, no?
And why did they take it out, if I may ask? Was it because of difficulty as a legal principle?
I will have to check the records, Mr. President, why exactly they deleted that. But again, Mr. President, no, if you find some wisdom to that, no, we are open for further discussion on the matter in the period of amendments. No? But the wisdom with this one is that we saw all of these prohibited acts in terms of a scale, where if they're done, if you're able to prove them at the minimum level of evidence, so they would be an administrative case. But as the evidence grows higher and the intent becomes clearer, then they become a criminal case. But again, Mr. President, if that is something we wish to debate on further or amend down the line, we would be open to that.
Because this is a special law, and therefore criminal intent, as we know, is not an element.
Yes.
And therefore, it is very important that we be very clear on these concepts, because it can be raised once prosecution is instituted under these provisions of this law. I am not prepared to come up with an opinion myself, but maybe it would be good if the sponsor can review that very closely, especially given the fact that, as the sponsor said, in the House version, they have dropped this they did not consider this as a criminal act.
Thank you very much, Mr. President. We will consider that.
Thank you, Senator Angara.
Thank you, Mr. President. Would the good sponsor confirm that all violations of the Act, as it stands right now, would be considered criminal, in fact?
Yes, Mr. President.
So, perhaps, Mr. President, one of the reasons why the House removed or made specific is because criminal violations contain elements, and to comply with due process under the Constitution, there must be people must know what they're violating. That's part of due process. You can't have a statute that is overbroad or vague. That could be one reason why the House made things more specific, because it's difficult to criminally punish somebody if they don't know what they're violating.
Yes. Actually, Mr. President, no. Again, most jurisdictions of fair competition commissions, the Federal Trade Commission, the Office of Competition of Japan. If I'm not mistaken, the majority, if not close to 80 to 90% of what they rule on are actually admin and civil liabilities, no? Not really criminal per se. It's just that in our case, some of the behavior of these cartels and monopolies are for me, are truly criminal already, because they're preying upon the Filipino populace, But again, Mr. President, and I humbly accept, that there might be a need to further refine this, and we will welcome that during the period of amendments. Thank you.
Thank you, Mr. President. If we could jump to the chapter on mergers, chapter 4, mergers and acquisitions. I noticed under section 2 that the bill has adopted a regime of compulsory notification.
Yes.
Is this correct, Mr. President?
Yes, Mr. President.
Yeah. And I note that in the ASEAN guidelines for competition law, they provide that depending on a jurisdiction or a state can adopt, as it chooses, a compulsory or voluntary notification regime. Is there any particular reason, Mr. President, why we have chosen a compulsory notification regime?
Because, Mr. President, if it's voluntary and you allow already the entities to merge, it will be more difficult down the line to ask them to dissolve, or to decouple. So, Mr. President, this actually saves everyone a lot of trouble because ahead of time they will know if it's allowed or not. But again, Mr. President, the two things. One is that if you're a company of a size that could be in a dominant position, you probably know that already, Mr. President. So initially, I find it quite lame, to say that I didn't know that I'm not covered by this because I didn't know I was dominant. When we all know, Mr. President, that most companies do track their place in the market. But on the other hand, Mr. President, on a parallel way, as the Commission is undertaking its operations, it will be sending out notices already to different industries, which actually might be in violation of this. So, Mr. President, probably, within the first year or 2 years of the Commission, they would have covered all of the industries, and people would have known, or the entities would have known already ahead of time. Now, if within that 1 or 2 years, we're hoping that these entities who want to merge with each other will give the courtesy to the FCC and provide that notice and allow themselves to be subjected to this law, Mr. President, rather than going on with it and then later on the FCC going into a ruling where they need to decouple.
Can the chair again ask a question on this, with the permission of Senator
Of course.
Angara? Let's say two companies would merge or merge a year ago, which resulted in their dominance of the market up to, say, 90%. All right. As the sponsor has said, you cannot decouple it now, assuming that the law becomes, assuming that this bill becomes law, meaning you cannot order that whatever contracts were signed will be declared as anti-competitive. Question: if this merged entity, which now dominates 90% of the market, would continue to restrict competition in the relevant market, would there be a criminal liability?
Yes. For the predatory behavior, Mr. President, or for the abuses of in their dominant position, then yes. Again, Mr. President, the principle of this law is that if they're already merged, the law is prospective. They
That's
cannot
correct, yes.
be unmerged. Now, if they're merged and they're not negatively affecting the market, then there would be no reason to decouple them or fine them or find them guilty of admin, civil, or criminal liability. But let's say, Mr. President, that they are doing acts which are abusive and
let's say they sell below cost.
which is and with the intent of cutting everybody out and therefore predatory pricing, then they would fall under this law, Mr. President.
Not because of the merger, but because of the
acts. Yes, Mr. President, exactly. It is penalizing the acts primarily. So everyone, once this law is passed, all relevant companies are such. No, they cannot be asked to unmerge anymore. But if they're found to be abusing their position, Mr. President, they will be fined, and one of the remedies could be actually to decouple them, no, as part of the remedies.
Thank you, Senator Angar.
Thank you, Mr. President. Going back to a remark made by the good sponsor, Mr. President, where he said that the player would know if he's a dominant player in the market. Does this presuppose that the Commission has already issued the relevant thresholds for dominance?
That's part of their functions, Mr. President, but I assume that it won't happen on the day that they're constituted. So I'm sure that they'll have to get to that, no, at some point. And the hope is that once they're constituted, that this can be one of the first things that they do.
Again, the issue is the arbitrariness or the fairness, or also the certainty of action in the business arena. Where, what if there are no thresholds in a certain industry by the Commission? How will an actor know if he's if a certain merger or acquisition would be covered or would require compulsory notification?
Well, Mr. President, no. If you look at the functions of the Commission, part of their function is to actually analyze per industry and say which mergers are actually not allowed, no? And this threshold per industry might be different. In one industry, it might be, if you put together two entities, 51%. In another one, it could be less, or it could be more, no? So, in effect, Mr. President, it is part of the job of the Commission to actually go around and analyze all of these industries and make sure that they do have that prior notice. So, I'm assuming, Mr. President, that prospectively, this shouldn't be a problem. But I do imagine that in the first few years, where they haven't finished all of that yet, no, all of this analysis, it might present some problems. But I would think, Mr. President, that this would come few and far between, no? Because most of the main industries anyway, where mergers of two entities or two or more entities could result in a dominant position per se, are actually quite limited, no, Mr. President, no? So, and we're talking about industries where there are really few players anyway. So I could imagine, Mr. President, that for these particular industries, kailangan nakatutok talaga yung Commission that any news of mergers, if they think that it's not going to be allowed, they should already mention it right away. But I'm assuming, Mr. President, that by the end of the second or third year, they would have had this industry analysis already down pat and quite open to the public.
So, is it safe to say, Mr. President, that before Section 2 on compulsory notification comes into play, the Commission must first issue the thresholds and publish such?
Yes, Mr. President.
Okay. And then that complies with some form of due process. I noticed that if a company or a certain transaction would produce a market concentration greater than the threshold provided in Section 2, there is a 30 calendar day period where the parties are prohibited from implementing their agreement. And if the Commission requires additional information from the parties, that extends another 30-day period.
Yes, Mr. President.
Is there a limit on the number of times the Commission may request information? Because it could be one way of a Commission delaying a business merger or decision.
Well, currently, Mr. President, there's no limit. But if you think that there should be a limit, then we can reckon that during the period of amendments or even during the IRR. But currently, Mr. President, we left it to the appreciation of the Commission because, in some cases it might be a totally new industry and they need to further study it. That's why we wanted to give them that leeway. But you're right, Mr. President, maybe an upper limit might be needed.
Because there's also a provision if the period expires and no decision has been handed down, it's as good as approved by the Commission. So it seems that the Commission is putting a premium. It seems the policy is to put a premium on facility or the ease of having a
Speed.
merger.
Yes,
Ah.
Mr. President.
And if we don't put that limit, then an abusive commission could actually perpetually ask for information, and then you have that 30-day period running over.
Okay, or Mr. President, if you want, you can even put a provision where after X number of days, if there's no decision, that it's a go, diba? Para that would be on the side of business, no? But we would welcome, Mr. President, any of these amendments to refine this provision further.
Thank you, Mr. President. Another related question on the FCC officials, because once they really receive this information, which I suppose is confidential or classified, and non-public in nature, because it probably is not revealed yet to the general public, but the commission is notified of a potential merger. There are certain dangers. For example, would you consider FCC employees insiders for purposes of insider trading, for example? Because
yes, Mr. President, they could be charged with that if indeed they let go of this confidential information, Mr. President. So there is no exemption to insider trading now that we have in the current law. So if it is found out that they engaged in this, then they could be charged with that now.
Let's talk a little bit about price fixing, Mr. President. In a U.S. Supreme Court case, the Colgate case, it was said that sellers may suggest rather than impose resale prices, but they can also refuse to deal with parties who do not follow suggested prices. Would such a doctrine be valid under the proposed law?
Mr. President, can you give me a second, please?
Certainly.
1 minute suspension.
Okay, Mr. President, ready to resume.
Session is resumed.
Mr. President, it's not a matter of price fixing agreement, Mr. President. Actually, it can be considered an abuse of dominant position for refusing to deal with the dealers, no? Because the dealers are other entities and they can decide on their own regarding the price that they're going to set for the particular product.
So that it would be a violation for the seller to refuse to deal with these parties.
Yes, Mr. President.
Who refuse to follow suggested prices. Thank you. What would be the applicability of U.S. precedents in general, Mr. President? Would these have persuasive effect, controlling effect?
I guess just persuasive, Mr. President, no? Because at the end of the day, the Commission will have to rule based on our current milieu and not the milieu of a U.S. case, which of course happened at another time and with another market. But I'm sure that the Commission may decide to use some of these precedents to help inform their decisions. But they're not bound. Obviously, we're not bound by any of these U.S. precedents, Mr. President.
Thank you, Mr. President. I ask because we borrowed a lot of the provisions, I think, from the U.S. The setup of the DOJ and the the Fair Trade Commission, the Fair Competition Commission, rather. So let me ask about the tying, what are called tying arrangements, where, for example, the sale of one product is conditioned on the purchase of a second product. Would this per se be unlawful?
Mr. President, on its face, no. But if it's used by a dominant player to extend its dominance to another market, that is already otherwise competitive, then it can be an abuse of dominant position. So in short, Mr. President, if I'm selling a bundled product, technically that's fine. Nothing wrong with that. But if one product comes from a dominant player and they are using their dominant position in one market to affect another market, then that could be considered also an abuse of their dominant position. In the same way, Mr. President, that within their own market, they're not allowed to abuse their dominant position. So if they're actually behaving properly in their own market, but using their dominant product to affect another market, then they could still be charged with abuse of dominant position.
That seems to be alluding to the Microsoft case in the U.S.
In
Europe?
In Europe, actually,
Yes.
Mr. President.
Because there is Mr. President, there is a phrase in Section 2E of Chapter 3 where it refers to making supply of particular goods or services dependent upon the purchase of other goods or services from the supplier which have no direct connection with the main goods or services to be supplied.
Yes.
Is that phrase, no direct connection, the operative phrase in deciding whether there's a violation or not? Or is it the dominant status of the actor?
What you have to look at, Mr. President, is that the secondary market is negatively affected. So I think, Mr. President, when it comes to deciding on cases of competition, the first thing that you really have to check is whether the market itself is affected negatively or not. So in that case, Mr. President, if a second product, for example, if secondary market is affected negatively, then and there is a connection to another product which is dominant in that market, then you can actually apply this, Mr. President.
What of the practice, for instance, Mr. President, of a TV station which sells airtime and it bundles its high and low rating stations and it tells its advertisers, well, if you want to advertise on this channel, you have to also advertise on one of our channels on cable, for example. Would that be an unlawful or a restriction of competition?
It's not, Mr. President, because you could still, meaning if it's meant as a promo, for example, or a savings to the potential advertiser, then it's fine. But if it's the only way, then that's a different question altogether, Mr. President. But if the advertiser does have a choice, now they have multiple choices. They can do one channel for X amount. If they do 2 or 3 channels and there's a benefit to that or a discount, that's actually fine. But if there is a restriction on the secondary market, then it becomes an issue of abuse of dominant position, Mr. President.
Could you explain the phrase restriction on secondary market, Mr. President?
If there is a choice, Mr. President, of the advertiser to buy it unbundled or to buy it bundled, then you cannot say that there is an abuse of dominant position or a lack of competition in the market. No. In short, Mr. President, if it's a promo and it's beneficial to the advertiser, then that's fine. So I think, Mr. President, in this case that you're talking about, if it's a requirement, for example, and you don't have any other choice, then that's another matter altogether. But if the case that you're talking about is that there are bundled promos which provide discounts, then that's fine, Mr. President. There's nothing wrong with that because it doesn't restrict on your capacity to engage the market.
Let me explain the example further, Mr. President. It's commonly done by some channels that they bundle their weaker channels with the strong channels so as to ensure that the advertisers also advertise on the weaker channels. So if there is no choice given to the advertisers, that would fall afoul of this law.
Mr. President, in the case of a TV channel, the market itself is quite competitive. So meaning, unless we're talking, Mr. President, about a hypothetical situation where it's the only channel
No.
that's in play.
Multiple channels.
If it's multiple channels, Mr. President, you could always decide to advertise in another channel. So
no
even the
violation.
dominant position of the first channel is put into question, Mr. President, because there are multiple channels that are available.
Okay.
So in a hypothetical where there's only one dominant channel, 95% of people or X% of people watch that, then they're forcing people to advertise in smaller channels, then that could be under this law, Mr. President. But in the case where there are multiple channels, which is the current situation now, an advertiser can actually choose not to engage in business with them and go to another channel.
I understand, Mr. President. That's clear enough. That's made clear by the sponsor. Thank you, Mr. President.
Thank you.
The issue of bid rigging by government agencies, Mr. President, since it was mentioned that this act would apply to the government too, could the government agencies also be punished for rigging competitive biddings, for example?
Actually, Mr. President, this was raised previously, and it is a cause for concern, because a lot of our issues, a number of our issues on corruption do involve bid rigging. In the case of bid rigging, Mr. President, the government agency could be charged with being an accomplice of an erring entity. Obviously, the bid winner, so they could actually be charged, Mr. President, as an accomplice to an entity who is charged with the provisions of this law. Because we'd like to clarify, Mr. President, that government agencies per se are not under the ambit of this law. So only private entities and GOCCs. But in the case where a government official rigs a bid, then the false bid winner can be charged with bid rigging, and the accomplice then, Mr. President, is the government official who facilitated that false win. So in that case, Mr. President, that agency official can still be charged, but as an accomplice to a private entity.
But not the government agency itself.
No, Mr. President. Unless, Mr. President, you can prove that the whole agency is... I think that would be quite difficult, Mr. President, if the whole agency would be complicit to the act, But it would probably fall upon a few officials, Mr. President, who are in cahoots with the bid rigger.
So that's clarified, Mr. President, that government agencies are not under the ambit of the law.
Yes, Mr. President.
If we go back to the definition of market and look at the different industries, for example, if we look at the banking industry, Mr. President, you see very big banks. The top three, probably Metrobank. We had the awards earlier, BDO, BPI. But then you also have very huge regional players like Nomura or Maybank. What would the relevant market be? Would it be Asia or would it be the Philippines?
It will depend on the particular product, Mr. President, because these entities do have different products, and some products would be competitive on a regional basis, and some would be competitive on a national basis. So it would really depend on the product in question, Mr. President. But this again goes back to the question of does the FCC have the capacity to judge, what the relevant market is? And currently, Mr. President, we left that to the appreciation of the FCC. And if there's a need to actually refine this further, Mr. President, we would be happy to amend this. But the wisdom there is that we kept it broad so that it won't come to a case where they cannot rule anymore on anything.
What about media, Mr. President? Would the relevant market be TV? Would it be radio? Would it be print? Or would it be all three?
We can even add the internet, Mr. President.
Internet, yeah,
YouTube
exactly.
and Netflix right. And all of these things.
That's right.
Again, Mr. President, it really depends on the appreciation of the FCC at that particular time. If you ask me, and I'm not going to be a FCC commissioner or the chairperson, these days, media is substitutable already. If you ask me, Mr. President, but again, we will be appointing, or the President will be appointing much more learned persons than me on this topic, and they will have to decide whether these different industries are already substitutable or not. But my personal opinion, Mr. President, is that they are substitutable already because clearly it's a world market already when it comes to media.
I would tend to agree with the sponsor, Mr. President, with respect to media. How about for transport, Mr. President? Would you delineate air? Would you delineate water? Would you delineate land transport, for example?
I would, Mr. President, but it would also depend on the particular purposes, Mr. President. And I think there's a quite accepted rule of thumb already that when it comes to the transportation industry, all these different sectors are considered as different industries. No, the shipping is different from the trucking, different from the air freight, and so on and so forth. No, but again, Mr. President, this is really my appreciation and probably yours as well. No, but we're leaving it to the FCC to be able to decide because, Mr. President, if this law takes a few years to pass, things might be different 2 or 3 years from now. And again, Mr. President, this is really both the difficulty and the opportunity of this law is that we are giving the FCC that leeway to be able to decide on these relevant markets, on products and services.
Yeah, I appreciate that need to be flexible, Mr. President. You look at the U.S., the laws are so old, but they still are enforced because it's judicial interpretation which really governs. There is a provision, Mr. President, on intellectual property. It's Chapter 8, Section 3, where it recognizes intellectual property but says shall not justify violation of this act. Copyright or trademark would not justify. I just want to know, because by its very operation, a copyright or a trademark would operate in a way that it would exclude competitors from using certain formulas or business secrets, so to speak. No,
Mr. President, we have to respect the intellectual property of a particular entity. No, I think that's we're not in conflict with that. So, Mr. President, if a particular entity has a new technology and they filed for a patent or a copyright in the case of media, then that must be respected by the Commission, and I don't think it comes into conflict, Mr. President, with the law that we have now. Because, Mr. President, you can still compete but have another IP. No, you don't have to use the same IP to be able to compete.
Mr. President, what about the constitution of the FCC? There is a period provided that it must be constituted within 1 year from passage of the act.
Yes, Mr. President.
Was wondering why it's a rather long period.
We were thinking that's a short period already, Mr. President. So if you want to make that shorter, we will accept that amendment, Mr. President.
Well, it was just a question, Mr. President, and we respect the judgment of the chairman who has studied the matter far more than this representation. And referring to the term of the office of the commissioners, there is a 2-term maximum. Just to clarify, this applies to both the commissioners and the chairman, meaning you cannot serve for 2 terms as a commissioner and then become the chairman. If you are a commissioner and you become the chairman, that already disqualifies you from...
Yes, Mr. President, because the chairman is part of the commission. So, broad definition of... I guess we'll need to clarify this, Mr. President, because a lot of commissions also have this complication. No? But the intent of the law is that you only serve for 2 terms. So it's not like you can do 2 terms as commissioner, then be appointed for 2 terms as chairman. No? That's not the intent of the law. The intent is that after 2 terms for any combination of positions, which is commissioner, chairman, chairman, commissioner, 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 you only serve 2 terms.
2 terms.
But we might need to clarify that, Mr. President, as maybe add a line just to clarify that further.
With the permission of Senator Angara, just on that point, can the sponsor look at very closely the demarcation of the powers and functions between the Commission and the DOJ? Because jurisdictions are important here, as this can be the source of litigation. For example, my reading may be wrong, but the measure provides that the DOJ shall have exclusive jurisdiction for the criminal enforcement of this act, including the investigation and prosecution of criminal cases filed hereunder. Practically all of the provisions would have a criminal penalty. Now, doesn't that leave the FCC with nothing else?
Mr. President, they may choose not to pursue because of a lack of the standard of evidence. The DOJ, Mr. President, because they're the highest, no? The highest standard of evidence, which is beyond reasonable doubt, no? So in effect, Mr. President, they may choose not to pursue because the standard is just a preponderance of evidence, for example.
Yeah.
But
the matter of pursuing or not pursuing is would not be proper because then you're trying to delineate the function of each agency. I guess what I'm saying is maybe you should take a second look at the way you have defined the functions of each agency, because it can lead to questions on jurisdiction.
Okay.
The second point is, can the FCC impose criminal sanctions?
No.
Meaning fines, penalties?
It's considered an administrative sanction, Mr. President, the fines.
Fines.
So it's not considered a criminal sanction.
So the imposition of sanctions, fines, or penalties, could this take the nature of a criminal sanction? Meaning that a fine is that it's not considered as a criminal, as an imposition of what is otherwise a criminal sanction.
It's not, Mr. President. It is currently defined as an administrative sanction. So, in effect, if you're found guilty by the FCC, you did not commit a crime, technically, no, because it's not criminal in nature. But you did violate administratively certain provisions, and thereby you had to pay a fine. So the sanction, Mr. President, is not criminal in nature, because they're not allowed to rule on criminal matters, Mr. President.
So that the understanding here is that what it does not involve imprisonment it's not an exercise of a judicial function.
It is an administrative function, Mr. President. So they rule only on administrative matters and civil liabilities.
Yeah, I know.
Mr. President, the way that the two offices were separated is not based on a difference of function, but a terms of scope. So one has been delineated for admin and civil, and the other one is criminal. Now, of course, Mr. President,
why do we have to make that distinction? Why can you not have only one agency so that there will be no questions on which agency would have jurisdiction over what?
Well, Mr. President, if of course, as former Secretary of the DOJ, you would have a lot of wisdom on this matter, and if that is something that we wish to take up in the period of amendments, we will be happy to take that up.
What I'm asking actually is for the sponsor to take a second look at the setup that is proposed in the bill, whether or not there is a basis for just having one office rather than having two offices. The criminal prosecution, just like, for example, the Commission on Election, okay, they enforce election laws, but when it comes to prosecution of criminal offenses under the election law, it's the Department of Justice. But they determine whether or not, in fact, there is a violation. So what I guess what the chair is saying is the sponsor may want to review these two heads enforcing the same law, because it can lead to a lot of questions, jurisdiction, and other matters which you can never predict what will happen in the future, so that the sponsor may wish to see whether or not there is validity in just having one agency for purposes of enforcing this law, but for purposes of prosecuting criminal prosecution, criminal offenses, it remains with the Department of Justice. Right now, for example, the SEC, I don't think the SEC prosecutes criminal cases arising from the Securities Act, for example. they do not prosecute cases.
Yes, Mr. President.
So,
We'll look into that, Mr. President, and revisit the journal, no, and the reasons why this ended up as such. But definitely, Mr. President, we will take that into consideration.
yeah,
Thank
please,
you.
I guess what the chair is saying is you may wish to review
Yes.
this particular setup of having two heads. You know,
I know, Mr. President, you're not a fan of having two
Two.
heads for any agency.
Yes.
So we'll
knowing this bureaucracy.
Yes, Mr. President. We'll take a look at that, sir. Thank you.
So, thank you, Senator.
Thank you, Mr. President. Just a few more matters, begging the indulgence of the good sponsor. Since we're talking about prosecution and enforcement, may I call the attention of the body to Chapter 7 on enforcement, where Section 1 provides for an inquiry into an anti-competitive case. The Commission is given the power to, either on a verified complaint by an interested party or motu proprio on its own initiative, it can initiate an inquiry for the enforcement of this act. My interest or my question is about the term interested party. Who would the interested parties be here? Is it all consumers? Must there be actual injury, for instance, Mr. President?
Mr. President, the idea here is that it's an affected entity, so it can be a consumer, it can be another company, Mr. President. But if you look at the principle of the law, which is that this is pro-consumer, and we're trying to create competitive markets so we can help our consumers with better quality products and prices, then technically, Mr. President, if you're allowed to buy a product of that industry, then you are already an interested party.
So practically all consumers, in effect, would.
Yes, Mr. President.
There is a proviso also in Section 1 that says a criminal case for violation can be instituted by a separate party or a private party directly in court unless there has been an inquiry conducted by the Commission and the same has been endorsed for filing by the Commission. I'm just a little confused with the operation of that unless and the proviso, Mr. President.
Mr. President, can you give me a suspension, please?
1 minute
Mr.
suspension.
Ready? Oh, sorry.
Ano? Konti na lang. Konti na. Ha? Sorry. Wrap up.
Ang masama doon,
request naman ng JBS to send the question. This is really fun.
Brad, pasensya na. Dito, medyo tumagal tayo. Sorry. Sorry, bro.
Pag-iisip ka na pare ng mga kasi nung magsa-start yung level 30, papanurin mo muna. Pag nag-tip-up mo. Kasi kanina nag-isip ako 3:40, inabot ko pa yung last 10 minutes. 2 o'clock dapat nag-start. At start mo na. Sama ka dapat na.
Session is resumed.
Mr. President, thank you for the comments, as well as Senator Angara's comments with regard to the procedures in terms of filing and raising cases to the appropriate appropriate agency, and we'll be taking this up offline, Mr. President. So we'll take all of these comments into consideration, Mr. President, and apply the wisdom appropriately.
Mr. President, I thank the sponsor for the clarifications made, but just to reflect it in the record, what we spoke about while session was suspended, the clarification made during the break was that a criminal case cannot be instituted directly by a private party in court, and can only be done when there is there is a finding or an inquiry conducted by the Commission. I just like to
Yes,
ask if
Mr.
that is
President.
indeed the...
That is the intent, and I think there is a need to clarify the particular syntax in the law to elucidate this further, Mr. President.
So that a private complainant cannot go directly to the Department of Justice to file a criminal complaint, but would have to go through the Fair Competition Commission, who will now determine whether or not there is a basis to file a complaint for preliminary investigation in the fiscal's office.
Yes, Mr. President.
All right. Thank you. And we should therefore make that provision very clear in the law.
We shall do so, Mr. President.
Yes, Mr. President, because the language of the proviso of Section 1 might indicate otherwise. And just to clarify also, Mr. President, what was said during the break, there is a independent private action for a separate and independent civil action by any private party under Section 20 of the same chapter that can proceed at any time. This was the clarification made. I'd like to confirm that.
Yes, Mr. President.
And this may also be the civil action which flows from the civil liability from a criminal act. So even if the FCC has not yet made a finding on the criminal liability, the private party can go directly to court to enforce his civil liability.
Yes, Mr. President.
His civil action. Thank you, Mr. President, for that clarification. And then we go to, there is a, just like the US, there's a provision on treble damages. That's Section 8 of the same chapter. Where would the damages accrue to? Does it accrue to the commission or to the treble damages? Does it accrue to the private complainant?
If it's a civil action or civil liability, Mr. President, it goes to the complainant, no? But if it's a administrative, it goes to the Treasury.
What if it's a class suit brought by the commission on behalf of the affected parties? Is there some kind of sharing on the treble damages?
Yes, Mr. President. It goes to all the parties who are a part of the class suit, no?
The 10% provision in the nolo contendere resolution does not apply to a class suit.
It does not, Mr. President.
I'd like to go to Section 10 of the same chapter, that letter H. It talks about inadmissibility of evidence, where a request for a binding ruling, a show cause order, or a proposal for consent judgment, the admissions, oral or written, made are not admissible in any administrative, civil, or criminal proceedings against such entities. I was just wondering for why we make these admissions inadmissible, Your Honor, Mr. President.
Because, Mr. President, they were intended to facilitate a settlement among the parties involved, and to use it against themselves would be unfair.
So it's a question of fairness to the parties.
Yes, Mr. President.
But what about the subsequent letter after inadmissibility of evidence in letter H? There is a provision which provides for modification or reversal of rulings. So that modification or reversal of ruling could not use. No. It could not be the basis, for example, of what is the status of that evidence used in an earlier consent judgment, for instance. Could it be the basis for a later change of decision by the, or is that a final decision on the matter?
Our sense, Mr. President, is that in the interest of fairness, it shouldn't be used, no? Because you used it, there was a settlement done, and then you change it based on the evidence submitted. That goes against the previous provision. But again, Mr. President, if there's an intention to clarify matters or to challenge this, then we could tackle that in the period of amendments. But the basic idea is it's not admissible.
I just asked, Mr. President, because that provision subsequent refers to a modification or referral whenever conditions of material fact or law have so changed. And in fact, it can be done by the commission motu proprio. So it seems to me that there's also an element of unfairness there.
I see.
I could be wrong, Mr. President.
Mr. President, if in the interest of fairness, there's an interest to change some of this or to skew it in the interest again of fairness, we would be happy to amend that, Mr. President.
Okay, Mr. President, the last question pertains to the privileged communication exclusion. It provides that nothing would require disclosure of privileged communications, but the entity who refuses to disclose the information must be obliged to give the name and address of the entity to whom such privileged communication was made. I'm just wondering if that would not in itself be a violation of the privilege.
Mr. President, the wisdom behind this is that in cases where competition is being, in cases of, in a competition case, the lack of information is really one of the killers of that case. No? Which is why, if you notice, there are provisions on getting documents, getting the right evidence, and in many cases of competition, it's really quite difficult. No? Even in terms of predatory pricing, you have to prove intent, which is in itself very difficult to prove. No? So this particular provision, I'll have to admit, its leaning is towards a quicker or more effective adjudication process, no, for the FCC. But again, Mr. President, if you as many of your questions today have shown, no, if there is an interest of due process or fairness that we are not seeing, we would be very happy to go over these provisions again with you, Mr. President, and amend if necessary.
Just the last, really, definitely the last question, Mr. President, is you mentioned the intent or effect in predatory pricing. I think in the statute it says it's intent and effect. Am I correct?
Yes, Mr. President.
Because the statute in the U.S. says intent or effect.
Yes.
So that was a deliberate effort by the committee to use the word and rather than or. There is a provision where it uses the word or, and there is a provision where it uses the word and, Mr. President.
Mr. President, maybe in this matter, no, our experts here are also divided on the issue. I would actually prefer intent and effect, no, because you want to see both the intention and the effect of the matter. But this is also something, I think, Mr. President, where your wisdom would also play a role, no. So we are open actually to changing this again, no. But as stated, Mr. President, it is and effect.
Just on that point, is it intent to violate the law and the effect of such act? Is that what is being clarified by Senator?
Yes, right now it's
actually, Mr. President, there's an and. No, there is a provision that says or, and there is a provision that says and, okay. And we need to clarify that. No. And again, Mr. President, in the period of amendments, we will clarify it.
The point of the chair is this. This is mala prohibita.
Yeah.
Intent is not material in mala prohibita. So that the mere act of the criminal offense is punished. This is the distinction between what is in the revised penal code and what is in the special law, as the lawyers know that in case it is in the revised penal code, you have to prove criminal intent. But if it is a special law, criminal intent is not necessary as an element. So can we clarify that?
We will, Mr. President. And this goes back to our discussion earlier about not including some of the acts which are criminalized, no?
Yes.
Because some of the other groups that we have spoken to have also basically are hoping that it's intent and effect because it's a criminal nature, no? Because the penalties are high. So, Mr. President, we thank the good sponsor for putting this on the record, and we'll clarify the two provisions which are not in consonance with each other.
But just bear in mind, and you ask your advisors, is that in a criminal special law, criminal intent is not necessary to prove.
Yes, that's right, Mr. President.
And here you're putting criminal intent.
That's right, Mr.
As an
President.
element.
Or the other way could be to follow the Congress and make some of the other prohibited acts not criminal, no? So basically, Mr. President, what we're grappling with is that we have these prohibited acts. They're all criminal in nature, and it's only the effect that we need to look at because this is a special law. Now, what Congress did, Mr. President, instead of putting in intent, was that they took out some of those prohibited acts as criminal in nature and kept just price fixing and cartel-like behavior as the criminal acts. So you raised this earlier, Mr. President, and we thank you for the wisdom that you had shared with us, and we'll take a look again if we need to look at the prohibited acts and the requirements for judgment on these.
Okay.
Thank you, Mr. President. I thank the gentleman, the good sponsor, for his patience. I just felt it was necessary to place this on the record. Thank you very much.
Thank you. I'd like to thank the gentleman from Aurora for his very extensive list of questions, and I'm sure that both his comments and suggestions as well as the Senate President will refine this bill further. Thank you very much, Mr. President.
The Majority Leader.
Thank you, Mr. President. Thank you to the two gentlemen. May I now move that we suspend consideration of Senate Bill number 2282 under Committee Report number 56.
Before the Chair acts on the motion, the Chair notices that in the agenda for the day, there are two other colleagues of ours who have indicated that they would want to raise questions.
Yes, Mr. President.
Namely, Senator Joseph Victor Ejercito and Senator Sergio Arasmeña III.
Yes, Mr. President.
The only reason why we bring this out is that, as the Minority Leader will confirm, this is among the measures that we have agreed in and the Majority Leader will confirm that this is one of the measures we agreed to have priority, give priority in our meetings with the House of Representatives. So
yes,
maybe we can just.
Mr. President, upon consultation with Senator Ejercito earlier, his interpellation is quite lengthy, so he would prefer that he do it tomorrow, so that he will not be interrupted.
Yes.
And I have also conveyed to the sponsor the favorable action or the inclination of both the House and Senate leadership to get this bill passed. So he's working on a timetable that will be acceptable to everyone,
Yes.
Mr. President.
So maybe if it will please the Majority Leader and the body, we can have this first in the agenda tomorrow, so that Senator Ejercito can raise the questions, so that we have this first item of the agenda tomorrow. Will the good sponsor be available tomorrow?
Available tomorrow. Yes, Mr. President.
All right. As the first item of the agenda.
Yes, Mr. President.
Thank you very much. Yes, so there is a motion that we suspend consideration of Senate Bill number 2282 under Committee Report 56. In objection, hearing none.
Mr. President, the other matters on the agenda today, the sponsors have requested more time. For example, the Senate Bill number 12 under Committee Report number 31, Barangay Workers, will be taken up on Wednesday. No. So with that note, Mr. President, I move that we adjourn the session until 3 o'clock in the afternoon of Tuesday, September 2, 2014.
In objection, hearing none, session is adjourned until 3 p.m. of September 2, 2014, 3 o'clock in the afternoon.